Hey guys, and welcome to today's video. Today, we have 4 videos to cover, with 3 of them being sovereign citizens, one of which is a follow-up. And the 4th video is one of the wildest moments where an idiot defendant thinks it's okay to yell at a judge. It's a Saturday, so grab some popcorn and your favorite crayon-flavored drink, and let's begin.
Mr. Renfro, you can come on. Alright, I have 3 files here. I have it's like 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373ON. People in the city of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And Attorney Odette.
Good afternoon, Your Honor. This is the time set for a pre-trial and possible motion hearing. I received no motions. I don't anticipate there being any at this time. And we're just asking if we continue to the jury trial date, as my associate has indicated that Mr. Renfro is not inclined to accept any sort of offer.
All right, thank you for that. And then, Mr. Renfro, can you go ahead and state your name for the record?
My name is Christopher Allen Renfro. Today, I am demanding a vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminals, so I'd like those vacated also. No, there was no proof nor burden that the testimony of the cop was proved to be true, and also no evidence. I still have not gotten discovery, which means it doesn't sound like the plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore them whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro made that he does not have?
There's a police report in the criminal matter, and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously, and he did not take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff, and that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, don't remember, we don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you want to give it to me?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere, when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason, because they don't carry any penalty of going to jail or anything like that. And so you aren't entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, Your Honor. Thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Second paragraph down. talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created.
Wrong? First, the Declaration of Independence isn't a legislative document. It's a declaration as stated in its title. And second, the Declaration of Independence does not say that you, as an individual, gets to decide whether you consent to being governed or not. If it was that easy, then every murderer facing trial would just use the "I don't consent to the governance of the state" defense.
What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. If, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to the King of England about what we wanted to see happen in this country. So that's not law. I wouldn't quote that anymore. I would quote
reasons why
other
I went to
things.
war with England.
One more
was
time.
Sam in America.
We don't interrupt each other. We're gonna keep doing this, and I'm gonna keep reminding you of that, because if you try to do it while we're having a jury trial, I'm gonna shut it down way faster, because we're not gonna do it in front of a jury. All right, so again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved.
Thank you, Your Honor.
We do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's already set. I believe there's already notice for the, I don't believe it was on set yet.
But it was not set for today.
If we set this for August 7th, Mr. Renfro, is that an acceptable, and I know no date is acceptable to you, but are you free on August 7th?
On summons, I'll be here.
Okay, all right, you'll get a notice. We won't send you a summons, but we will send you a notice for you to
Only
be here.
summons a little bit.
Well, if you don't show up, I'm gonna issue a bench warrant for your arrest, so be fair warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we have to bring the jury back. Last thing before we leave, Attorney O'Day, you mentioned that, actually, there's two more things I want to talk about before we leave. One, you mentioned that today was set for pre-trial and motion, and I do have as well have it, there was no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay, all right, so I don't know why that was set for that. I know you made an oral motion today, but, all right. Well, then that's not an issue. I will also note that right now, the jury trial actually has a date for Friday, September 5th at 9 o'clock.
Yes, that was the date that we subpoenaed the
That
officers.
is the date of Mr. Renfro's trial.
Okay,
When we originally scheduled the to coincide,
gotcha,
and it just kept moving forward.
gotcha. All right, so we want to do August 7th or September 5th, it's like either day is gonna be fine.
Well, I think of course discretion.
I'd say August 7th is good a date as any, so we're gonna, we had it originally set for, I think it was, yeah, July 25th, we had to move it because there was, some kind of emergency or something. I don't remember what happened on that date, but it was something weird. So then we moved it, but we'll move it back to August 7th, that way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
It ain't my intention to present this cause.
Okay, you do not want me to ask the public defender's office to appoint you an attorney, is that right? You don't want that, right? And you do not want to retain an attorney, is that right?
Right, I'm competent and I will see these matters through myself.
Okay, so that's the end of the first hearing. I'll definitely be covering his next appearance, which should be transcribed and added to the National Archives as a declaration of dumb fuckery. Next, we head to Judge Hillman's courtroom, where we have a sovereign citizen who's decided that he's going to sue the police for doing their jobs by issuing a trespass warning to a soft shithead who refused to leave a tow yard.
Set that matter aside. All right, next matter is Anthony Blackman versus Harrison Bragdon, case number 251186GC. Is counsel here for the plaintiff? Or is plaintiff present?
Yes.
Anthony Blackman?
Yes.
Can you turn on your camera, sir, and turn up your volume?
Can you hear me now?
Okay, still I'm having a hard time hearing you. Can see if we can get the volume up.
There's not a mic deal here. Let me see. How about now?
Yes, I can hear you now. Thank you. All right. Good morning, sir. Is counsel here for defendant?
Yes, Your Honor. Sarah Osborne here on behalf of defendants Harrison Bragdon and Kelsey Simison.
Will they
Okay.
not be in court today?
Good morning.
Good morning, Your Honor.
Okay, sir, I conduct the proceedings, so please, until you're addressed, please do not speak freely. This is the time set for defendant's motion for summary disposition. The motion was filed back on May 8th. I do not see any response from Mr. Blackman. Mr. Blackman, did you file a written response to the motion?
I did.
When did you file that, sir?
Shortly, 10 days after that, I'm sure they had that in the
Yeah, I
court.
can't hear you when you're turned sideways like that.
And to go to court, to take it to trial, and face
So when did you file a written response to the motion?
May.
In May.
28th. Yeah,
What day?
28th.
May 28th. Okay, I don't see anything in the file from May 28th. I see that you filed an answer in this case back on February 27th to 25, or a document. There is also the summons and complaint form, which were filed February 27th.
Yeah, I definitely filed it. I sent everyone a copy.
Ms. Osborne, did you receive a copy of a response to the motion from the defendant?
I did not, Your Honor.
Okay. Did you serve it on the lawyer for the defendant, Mr. Blackman?
Okay, let's.
Is a yes or no, sir?
Yeah, that's what I'm getting to. I
can't hear you, sir.
I'm actually trying to figure out what exactly she wants out of this summary disposition. It means she's
Okay.
Basically.
All right. Well, I'm gonna hear from Ms. Osborne. Ms. Osborne, it's your motion. You filed it with the court. You served it on Mr. Blackman. So please state your position in the case.
Thank you, Your Honor. Your Honor, we've attached a brief in support of our motion for summary disposition, which I will rely on here today, along with the cases cited therein. Your Honor, and it's, a lengthy brief. I don't want to take the court's time by rehashing every point raised. So, Your Honor, if there are any questions you have of me, I'm happy to answer those. But as a quick summary of the arguments set forth in our brief, first and foremost, we have not received a response from the plaintiff here, Mr. Blackman. And my position today is that he has not met his burden to establish that a genuine issue of material fact exists. Aside from that, as indicated in our brief in support, Mr. Blackman has not comported with the basic rules of pleadings. He hasn't set forth factual allegations to establish how his due process rights were violated, what actions each individual defendant, Mr. or Deputy Bragdon and Deputy Simison, what they did that specifically violated his rights. There's no allegation of how a safety search and a brief detainment would violate his rights. He doesn't clearly articulate any particular cause of action. By reading his very brief allegations, I have sort of surmised what the claim is in order to file our motion, but the complaint does not meet the rules for pleadings. And the claims are so unintelligible that it's practically impossible for the defendants here to ascertain the nature of the claims that they have to defend.
I think what the attorney is trying to say is that she couldn't see past the drool on the construction paper to understand what he's actually suing them for. In other words, it's a classic sovereign citizen court filing.
Next, we've also asserted that these defendants are both protected by qualified immunity for any claims of due process violations or cruel and unusual punishment. Plaintiff hasn't set forth what conduct that was undertaken by either defendant that violated a clearly established statutory or constitutionally protected right, of which a reasonable person would have known. There are no facts alleged to support that either Deputy Bragdon or Simison violated his constitutional rights. He has not alleged that defendants were unable, pursuant to well-established law, to search and detain him, particularly since Mr. Blackman had been trespassed from the Schroyer towing. Previously, he was clearly there, had been in their lobby, was, to the extent that they had called the police, called 911, the deputies were dispatched and gave him an opportunity to leave. He refused to leave.
Why would I be?
He ended up being informed of the trespass warning. He was
In a lawsuit.
again.
Mr. Blackman, I advised you not to speak until you're recognized by the court to speak. So you're interrupting the proceedings. Please stop doing so and let Ms. Osborne continue. Please continue, Ms. Osborne.
Thank you, Your Honor. He was given an opportunity to leave, failed to leave, even though he was advised that there was a trespass warning. And we've attached that documentation to our complaint, or to our, our motion for summary disposition. And as they had a person who was appeared to be violating the terms of a no trespass warning, they then had to investigate the matter. They did a safety search, briefly detained him in a squad car, interviewed representatives from Schroyer, and then issued a citation. From dispatch at 5:20 p.m. to issuance of the citation at 6:30 p.m. was less than an hour total time. So there is nothing that either deputies would have been aware of or should have been aware of any of those actions that would have would clearly have violated an established constitutional right.
Did he also have a warrant out of Lansing, 54A District Court?
I believe there was a warrant, and I think that was followed up on, and I think that was a situation where they were informed to advise and not detain him on the warrant. But they did have to call it in and check on it, get the status. So here, Mr. Blackman hasn't established or pled
Right to own his own
that
property.
he was, or that the defendants are not entitled to qualified immunity. So that is the obligation there.
All right, Ms. Osborne, I think I've heard enough.
Okay.
Mr. Blackman, So you didn't file a written response. Neither the defense lawyer or the court has your written response. What would you like to tell the court, sir?
Everything is in the summons. Now, I wouldn't be in a junkyard trespassing on just vacational, thrill. There's no thrill in being in a junkyard in the first place. I'm there. They had towed my car saying that I had no proper plates on it. They've been had it for over months and months and years have passed. I took them to court already. I've been over there 1,000 times. They telling me that I don't deserve my property. Called the officers. Not only are the officers violating due process, but the Meridian or Ingham County sheriffs are violating due process. I have a right to my property. Nobody has a right to detain me or the authority to detain me over me picking up my property. They don't have a right to my property. That's all in the report, all in the summons, and that's the situation. And if the court doesn't bring them in and serve justice, there is no justice. I've got a lot of money tied up into this car, over like $100,000, and you're going to tell me some trespassing, which is a misdemeanor, that's more important than them retrieving my property as a citizen of the United States.
Well, as a citizen of the United States, you should understand that those roads you transport your property on are maintained and paid for by the registration fees that you refuse to pay. And speaking of which, can you imagine putting hundreds of thousands of dollars into your car and legal processes and still refusing to put in the $100 or so per year it would cost you to avoid being deprived of your property? It's starting to sound more and more like a you problem, and the judge seems to agree.
Okay, thank you, sir. All right, well, the court has reviewed the file, reviewed the complaint, and reviewed the motion for summary disposition. I do find that the defendants are entitled to summary disposition of the claims. Mr. Blackman, you did not file a written response as required under the court rule 2.116, and you have not alleged or pled in your complaint an exception to governmental immunity, and you've not presented a valid claim that the court can determine. So I am going to grant summary disposition, and Ms. Osborne, you'll need to submit a order to the court for entry. Mr. Blackman, if you think my decision is wrong, you have the ability to appeal it to the circuit court. You'll need to follow the court rules in making that appeal. Following the court rules is a necessary party, even though a necessary procedure, even though you're not represented by a lawyer in the case. So that's all for the record in that matter. Thank you.
Thank you, Your Honor.
Welcome.
Now we head to our third hearing, which is a follow-up to a couple of sovereign citizens who got into a roadside argument with police and lost their window in the process. I'll add a couple of links above me in a card, just in case you want to see the previous appearances and the wonderful window smash that preceded these proceedings.
You're welcome. We'll now be on the record in, did we not do Height? I thought we did.
We have not yet, Your Honor.
Oh, he's the one that didn't have his name on the screen. We're on the record in 2025 TR 1215, State of Kansas versus Quenton Height. Brett Sweeney for the state. The defendant appears in person and per se. Mr. Height, count one, you're charged with driving without your license and possession when demanded, an unclassified misdemeanor, a sentence up to 30 days and $500 maximum fines. And count two, driving without registration or tag, an unclassified misdemeanor, up to 2,500 in fines, and 30 days to 6 months. How do you want to proceed, sir?
Good morning, Your Honor. My name is Quenton Height, the accused in this matter. I'd like to briefly state for the record that I have made good faith efforts to meet with the prosecution prior to today's proceedings. I called the Butler County Attorney's Office twice and had in-person meeting times set up to discuss a dismissal agreement with the intention to obtain and present a valid Kansas driver's license, insurance, and registration on the car involved. Unfortunately, I was rescheduled on both occasions. The most recent meeting was scheduled for yesterday afternoon, but I was informed that Jared Regier had jury duty this week. At 7:55 a.m. this morning, I sent an email proposing a dismissal agreement. I also called the office at 8:19 a.m. to speak with Mr. Jared and his team, but unfortunately, Jared and both Brett Sweeney were unavailable. With that said, I am not sure if Mr. Sweeney was made aware of my meeting attempts, emails, or phone calls this morning by the receptionist in the county attorney's office this morning. Additionally, I do have a meeting set in person for August 7th at 3 p.m. for the discussion of the same matter. Given these circumstances, I request a continuance. I believe with a short amount of additional time, we may be able to resolve this matter efficiently without burdening the court. I'm also available to meet with the prosecution in person over the phone after court today or before 1 p.m. tomorrow. I'm also available to register my car on the same timeline to satisfy the diversion agreement. I respectfully ask the court for a brief continuance so that I may pursue this resolution opportunity directly with the county attorney's office. Thank you, Your Honor, and I yield.
Well, hey, at least he and the degenerates he surrounds himself with are finally understanding that your vehicles must be registered and a driver's license must be obtained before any traveling behind the wheel of a vehicle on public roadways is legal.
All right, so are you waiving your right to counsel then and representing yourself?
I am presenting myself today.
And you understand that you can hire any attorney, and if you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify?
I do comprehend, yes.
Okay. Would you wish to proceed on your own behalf? Is anyone making you give up your right to an attorney?
No one.
All right. Well, I'm showing that you have knowingly and voluntarily waived your right to counsel so you can represent yourself. With that, please, in the journal entry and docket notes. Next, have you looked online at the diversion program to see if you are interested in that?
I have not had an opportunity to do so. As I had stated, I was hoping to discuss the terms in person with Mr. Regier, or hopefully this morning, Mr. Sweeney, but they were both unavailable. So at this time, I have not reviewed the terms, no.
Looks like you have some pending cases in about at least 2 other counties. Does that sound right?
I would like to say that those matters are separate. I don't know if that is true or correct.
Well, 2 of them are in Butler County. It looks like one in Sedgwick. Let me see when the court date is so we can maybe put them together.
And Your Honor, I was going to mention that this case has actually already been set on Chief Judge Ricky's docket for another hearing, August 25th at 3 p.m.
May I ask, Destiny, are you talking in regards to the current matter that we were discussing today, the 1215?
Yes, it's regarding this case. It's going to be set with the other case as well, though.
Interesting.
Right.
Okay.
Okay, so Judge Ricky reassigning these 2 cases to himself?
He is, Your Honor.
Okay. Is there a felony case, Mr. Height?
I'm sorry, say again, please.
Well, I was just curious why Judge Ricky would snag 2 misdemeanors out of the group here. Do you have a felony case pending with Judge Ricky?
Not that I'm aware of, and as of my first hearing on the other aforementioned matter, he said he would not be lumping these 2 together. So this is of news to me. I was not made aware of this. And I also did state that my preference would be to have them separate, and he agreed as such. So this is interesting to me.
Well, it's really not that interesting, as it's common for the courts to combine matters like these for judicial efficiency.
Mr. Sweeney, any information you might be able to have or like to shed on this?
Just kind of hearsay, Your Honor. Mr. Regier, prepping me for today's docket, did talk to me about this case and said that maybe he had a meeting coming up with the defendant. But he did mention that Judge Rickey rather took one of the cases. But my understanding, in speaking with Mr. Regier, is that the other case was to remain in front of Your Honor. So. All of them are misdemeanors, of course, including this one. But my understanding is that he was retaining one of the misdemeanors, but this traffic case was to remain down here. I could be incorrect, but that's what I understood in speaking with him.
And I believe that was what was previously stated. I do have a note as well on this case in the 25 TR 1215 from Judge Rickey's assistant, stating that it's to be moved and set for August 25th at 3 p.m.
Okay.
All right, Mr. Height, I'm not sure what Judge Rickey has in mind, but I trust he does, beyond any doubt. So we're going to move this case to Judge Rickey's docket, August 25th at 2:30.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. An unclassified, two unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Rickey. Did he say whether you wanted that by Zoom or in person? Counsel,
my request would be to be in person. And also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
okay. All right, well, you may go, sir. Choose from these proceedings. Just make sure you reappear at the date and time given.
Okay, and one more time for me, please. The date.
August 25th at 2:30. Didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay, you might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Well, it's definitely in your best interest to take the free attorney, especially since they can help you resolve these matters in the most efficient and beneficial ways for yourself. But like my mama always used to say, you can lead a horse's ass to water, but he still has to learn to drink from his mouth. Now we head to our final hearing, which is before one of my favorite judges to watch, Judge Perkins, where we have a total and complete degenerate whose sole purpose in life is to be angry and make his situation worse than it already is.
Are you driving, sir? Are you driving?
For me?
Mr. Glenn, Rondelle Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Yeah, but how long am I going to be sitting here? I haven't spoke to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. Listen, it's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but, man, I can't be sitting out in the sun.
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location. Right. Mr. Rondelle Glenn's license, please. City of Detroit versus Rondelle Glenn. Case number SP 11-54208, counts 1, 2, and 3. SP 11-54212, counts 1 and counts 2. SP 14-82930, counts 1 and counts 2. SP 172-0494, counts 1, 2, and 3. SP 172-0600, counts 1 and counts 2. SP 172-0615, counts 1, 2, and 3. SP 173-0688, counts 1, 2, and 3. SP 173-06961. State of Michigan versus Rondelle Glenn. Case number SX 3397163. SX 3630039. SX 3639504. 18443135. Appearance for the record, please.
Attorney Gaten Robinson on behalf of Mr. Rondelle Glenn. Mr. Glenn, please state your name for the record.
Mr. Rondelle Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect for the court, and he's
Wait a minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the judicial tender commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58 years old.
You still haven't learned. Not only are you still driving while on Zoom, which is highly dangerous for yourself and the people around your 2-ton death machine, but the judge is not your bro, nor is he your man, and he has the power to throw your ass in jail for contempt. So show a little bit of respect, and I promise you, it'll go a long way.
That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he was driving while in court. I asked Mr. Glenn that he's driving. He said he's driving to go in to get something to eat, I believe. So now
Mr. Glenn wasn't driving. Somebody was driving for me. I'm with somebody. What do you mean? What do you mean, man?
I'm
I'm 58 years old, bro. Look.
Mr. Glenn, I'm trying to help you. Can you please just wait a minute?
All these tickets from 20 years ago when it's only 3. You know what I'm saying?
Sir, stop. Mr. Glenn, stop so I can help you. I'm trying my very best to help you. You got a chip on your shoulder, but it's not. Sir, give me a minute. I'm gonna try to take you in a breakout room and talk to you before you make your circumstance worse. Just be quiet until you get there, please.
Yeah. Okay.
Thank
you. Mr. Glenn, after you finish talking to him, I'm gonna give him a pretrial date for tomorrow. Mr. Glenn has to come into court in person.
Fine. I'm going to the Judicial Tender Commission because you're very impartial. You're not about to try to embarrass me in court like that, man.
Glenn, stop.
Mr. Glenn, when we only got 3.
Just ask you to be quiet so I can help you.
I'm going to file a complaint today.
That's fine. You can do whatever you want, but
you're not about to try to embarrass me like that, be disrespectful to me, and think I'm gonna sit up and take that.
Mr. Glenn. Mr. Glenn.
And they come to court properly dressed. Don't come to court in a sleeveless shirt. Come to court properly dressed.
Your Honor, can I please have a moment to talk to Mr. Glenn? I muted you because you're not making it better. Just be quiet.
It doesn't matter what you say to him. He's going to take an anger management class too.
Your Honor, I'm going to move Mr. Glenn to another breakout room.
Very good.
He's the Motorola device.
Yes. Move past the matter. Tell them to come to court properly dressed, Ms. Gaten.
Mr. Glenn, you should have a prompt to go to breakout room 5. Go to breakout room 5. Look at your device, Mr. Glenn. You should have a prompt on your screen to go to breakout room 5. Just click OK.
All right.
All right, Mr. Glenn, I'm gonna send you a different prompt. Just when you see the room number pop up, please just click OK. You're going to room 8.
All right, let's pass
Just
the
click
map.
OK.
In person tomorrow, Miss. Let's
I
pass the
understand,
map.
Your Honor.
Let's
You
go
want him
back
here
on.
at 9 a.m.?
No, 8:30.
Am I releasing him?
Yeah, you can do whatever you want to, but
Okay, Your Honor. Thank you.
So the public defender, who's trying to help him out, takes the defendant into a breakout room. And judging by the look of frustration on her face, you can tell that he was being just as difficult with her as he was with Judge Perkins. And it's been my experience in life that when everyone around you is the problem, it's probably you who are the asshole.
Miss Gaten Robinson, are you still dealing with Mr. Glenn?
Your Honor, Mr. Glenn was not the easiest to try to talk to or get to reason with. He has indicated to me, is he still in the breakout room? He told me he was coming down to the court today. He doesn't understand why he has to come tomorrow, so he's coming down to talk to the chief judge today, which I told him that is absolutely his right. He could. He felt like you were picking on him by calling out his older tickets. I explained to him that that is your process and the process of many judges down there, that when people have outstanding matters, if they are on your docket, you will pull all of their matters in an attempt to be efficient. And you've done that with multiple clients of mine this morning to try to reassure him that that was not you picking on him. He didn't understand why you were bringing up old stuff. So I explained to him that that's you trying to be efficient because he had multiple tickets in front of the court outside of the 3 that were on the docket. I indicated to him that he was supposed to be here tomorrow at 8:30 in the morning.
He's here. Let me bring him. Hold on. Let me pass it right quick. Let me get Mr. Galarza out of here. He's not going too far.
He's coming in on Zoom or he's coming in on court.
Now I get. You said what? You are making it viral. Who's it going? This is what he wants to make himself.
I got his attention. He's aware that we're trying to pull him back into the breakout room. I'm about to send him a prompt. To the main session. I'm about to send him a prompt.
I'm trying to get him in the main. Stop close the rooms.
Okay.
Now, if he keeps it up, he'll find himself in contempt.
Your Honor, I'm trying to save him, but.
And I know it's probably going to be ordered as a transcript. So can y'all please talk at one time at a time?
Well, good luck. Good luck. You can get the video.
Sure.
All right. Let's go back on the record with Mr. Glenn. Mr. Glenn, let me say something to you, sir. Start your video, please.
I got it going. Get it straight now. Get it straight, bro. I simply wanted to come in and plead not guilty. But
so, Mr. Glenn, I asked you to stop talking to the judge like he's your friend or somebody on the street. You would not talk to another judge in a different jurisdiction like that. He's not your bro. He's Judge Perkins.
Now, let me stop. Let me stop right
I'm trying to help you, Mr. Glenn. You're making it worse.
Stop, Ms. Gaten Robinson, please. Mr. Glenn, let's get this understanding. First of all, I'm not your bro, okay? Yeah, I'm the judge, Mr. Perkins, but I'm not your bro, okay? Second,
I know you're not.
No, I didn't ask you to speak. Don't talk while I'm talking. Secondly, if you continue to act out like you've been doing, I'm gonna have no choice but to hold you in contempt of court, okay? And I don't want to do that. I'm trying to exercise the utmost restraint with you. Now, third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you so you don't have to keep coming back to court multiple times and you don't have these warrants sitting out here on you, okay? That's why I called those cases into the record. That's my choice to do that. And I called the cases into the record for the court and for your benefit so you don't have to keep coming back to court, okay? So
Okay, I appreciate that.
You could show your appreciation by just dropping the attitude and understanding that it's not Judge Perkins or any other judge's fault that you find yourself in the position you're in today.
Look, I'm gonna let you speak. Let me finish. You're gonna come into court in person tomorrow at 8:30. I want you properly dressed. You can say what you want to do what you want to say. If you don't appear, then a lot of people don't show up. That's what the court has to say. Now, you want to talk? Go ahead and speak.
Okay. So I'm sorry about calling you bro. Okay. But I didn't think that you would get impartial and start, you were supposed to be here early. I'm 58 years old. Okay. So I'm kind of tech challenged, but I called down and I got in. Okay. I was late, but I got in, but it's just the way you was talking to me, that had me like, damn, I don't really want to go in front of this guy here, man. Plus I know Todd. So that's another reason why. Okay. So I was just asking if you could just recruit yourself. Then I found out some other stuff that's something, that's going on. Some news is going on right now. I don't want to be a part of that. I just want to go to another courtroom. If we could do it like that, then we good. Then I don't have to go down to the Judicial Tenure Commission, file a 3-page report. You know what I'm saying? Just recruit me from your courtroom. That's all I'm asking you.
So, Mr. Glenn.
On the grounds of, maybe not because I don't think you're impartial, but.
Let me finish. Let him go ahead and finish.
Okay. Maybe not because I felt you were being impartial, but let's not say that. But I do know Todd personally. Been knowing Todd for a long time. So that's another issue. Not the other issue about what's going on with you now, but I'm just asking the court, please, just recruit yourself or just send me to another judge and I'll appreciate it.
All right, let me, I'm not gonna send you to another judge. I want you to come down tomorrow morning at 8:30. I accept your apology about the bro situation. I didn't hold you being late against you because I did let you in the room. As long as I'm sitting here, I question why people are late. I understand now why you're late. You told me you're not as tech savvy as other people. And that was it. You also were driving in court. You admitted to that. You have a
no, so let's clear that up. Listen, I have a business.
It's cleared up in the court's eyes. It's cleared up in the court's eyes. It's all being recorded. It's on transcript. You admitted to that. Okay. So you can say whatever you want. I let you speak. Speak, and I'm speaking. I said, do not interrupt the court. All right. So this is it. We're not gonna keep going back and forth. I'm gonna let you go about your day, but come down tomorrow morning in person. And you can go to the Judicial Tenure Commission. That is your full right. You can go to the chief judge, but I'm not going to sit here and have you yelling at my staff or anything. Okay.
Your Honor.
Listen, I'm not a
Mr. Glenn, please give me one moment. Please, I've been begging you since the beginning of our interaction. I'm trying to help you. Just be quiet.
Right. I should have brought my boy Blake in here. I wouldn't have all this.
Okay, so one moment, Your Honor. I explained to Mr. Glenn that he does have to be at court tomorrow morning at 8:30. I did also indicate to him that it's his absolute right to retain an attorney. If he is not able to retain an attorney, then he can ask for an appointed attorney tomorrow. Because he is here for misdemeanor matters, he is entitled to counsel. If he wants to pay his own counsel or ask for counsel tomorrow, that is his right. But I'm making it clear that Mr. Glenn is aware of his right to have counsel tomorrow at court.
All right.
If Mr. Glenn come to court, he's coming with all the news coverage.
Oh yes, please bring the news. Because more than just YouTubers like myself, Colin, Hutch, and Old Squishy Gardner need to be highlighting morons like yourself so that other people don't screw up their lives too. Nevertheless, Judge Perkins assigned the matter for the next day, and it was in person, so we don't have the conclusion to this case. And I checked the news, and they didn't cover it either. So either he didn't call the news, or they laughed at him just as hard as I am.
Okay, so we just want to make sure everything is good.
We'll see you in the morning at 8:30. Make sure you look for the news.
I want another judge, and I make with another attorney.
Okay. One at a time, court reporters.
Put your good suit on. We don't care about you coming with the media. Look good for the
I know you
media.
don't
Put your
care. That's
suit
why I
on
don't want you.
and bring.
You know what? As a matter of fact,
I'm
you're
not-
on ineffective counsel too. So I'm good.
Okay.
We're gonna reschedule that.
Have a
I'll tell you
wonderful
what we'll
day,
do.
sir.
Let's handle it like this.
Stop it, Miss.
Have a
Don't
wonderful
say
day.
anymore, Miss. Don't say anymore, Miss Robinson, please. Mr. Glenn, that's it, okay? I'll let you make your record. Come on down tomorrow morning, all right? Yeah, you're muted. You're muted now. Unmute him, please. Unmute yourself. Unmute yourself. All right,
Let me
Mr. Glenn.
let me do what I gotta do. Okay. Yeah. All right. Bye-bye.
Best of luck to you, sir.
Yeah. Take care.
You too. All right.
Okay guys, that's the end of the hearing and the end of today's video. If any of these cases have follow-ups, I'll be sure to bring it directly to you. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.